Good afternoon, Mr. Makhura.
Good afternoon, Chief Justice.
How are you this afternoon?
I am doing fine. And how are you, Chief Justice?
No, I'm all right, thank you. All the commissioners are all right, too.
Thank you. I was not trying to be discriminatory.
Welcome. I welcome you on behalf of all the commissioners to this interview. Thank you for availing yourself for consideration for appointment to one of the positions in the Labor Court as a judge of the Labor Court. I'm going to ask you some questions. Other commissioners will also ask you questions. We will be asking you questions to satisfy ourselves as to how you satisfy the selection criteria that we have adopted as the commission for the selection of judges.
Thank you, Chief Justice.
In the course of our questioning you, we may be robust, but we will not in any way be intending to humiliate you or demean you in any way. You understand?
I do, and thank you very much, Chief Justice.
All we will be trying to do is just satisfy ourselves
Indeed.
Whether you meet the requirements and meet the criteria.
Thank you very much.
Okay. Now, you hold an LLB degree, is that right?
Correct.
That is the 4-year LLB degree.
Indeed.
Okay. You also have an advanced administrative law certificate.
Correct, Chief Justice.
But next to it, you wrote electrical engineering, or is that another one? Another certificate?
It's another certificate that I did just after my matric, Chief Justice.
Oh, okay. And you got your LLB from VETS?
Correct, Chief Justice.
In 2005?
Correct.
Okay. And did you then do articles at Chettle Thompson and Haysom?
Correct, Chief Justice, from 2006.
From 2006?
Correct.
And so you know the previous candidate quite well?
He is my colleague. We interact very often.
Oh, did you conspire to make yourselves available together?
Not at all, Chief Justice.
Okay, all right.
This is a city age capture.
You're city age cadres?
We are, as we are commonly known to represent trade unions and employees.
Okay. And when were you admitted as an attorney? Was it in 2010?
2008, 19 May. Chief
or
Justice.
2008?
Yes.
Okay. And you then practiced as an attorney, and you continue to practice as an attorney up to now?
Correct, Chief Justice.
Or you are still at CTH?
I am. I'm a very loyal...
So you all want to leave CTH at the same time?
Chief
you
Justice,
all want to leave CTH at the same time?
I will not comment on that. Thank you very much.
No, but you have said you are very loyal, so I take that you. That's what I will stick to. Now, how many years, therefore, have you been in practice as an attorney? Is it about 15?
It's over 15 years now, Chief Justice.
Over 15 years.
Yes.
CTH is well known for labor law work, and I think maybe some constitutional law work, but I think, to my knowledge, the constitutional law work was limited. Most of the practice was about labor law. Is that correct?
We have really diversified our practice over the time, so we do have administrative public procurement matters that we are doing.
Yes.
Yes.
So your own practice, what kind of, how diversified is it?
My own
what kind of branches of law do you get involved in your practice?
My own practice, Chief Justice, is predominantly labor law.
Yeah.
I do, however, advise clients on some contractual issues, service level agreements. I have limited matters currently in the one in the merge court. I think 2 in the merge court and 1 that I can think of in the high court, dealing with contractual issues. Otherwise, throughout my career, I've done a number of other matters like your defamation cases. Chief Justice will know, representing trade unions in the past years, there used to be those defamation cases between the employers against the trade union, or shop stewards, and all of that. So I have done a number of those matters during the time when I was an associate.
Yeah. So your exposure has been to labor law, some delictual matters.
Very
is that
limited.
right?
Very limited delictual.
Very limited.
Yes.
Yeah, so it's mainly, as you
Yes.
said, mainly labor law.
Yes, and I think I also do indicate limited criminal law practice.
Yes.
Doing bail applications for those trade union members who will be arrested or who were arrested
Yes.
previously, yes.
Okay, all right. Have you been doing appearances yourself in the labor court and arguing matters yourself and conducting trials yourself as opposed to briefing counsel?
Yes, Chief Justice. I have indicated also in my application that I do occasional appearance, and that's the word I chose because I don't think I appear more than 12 times, and I think it's debatable what is regular appearance.
Yes.
But I do appear most of the times. I do my trials. I've got a part-head trial now. I've got a trial coming up in October that I'm running. So I have appeared in motion proceedings.
Yes, but you talked about 12. Is it 12 matters in which you appeared without counsel?
Is that what I indicated, Chief Justice, in my application? If that is so, that will be the number of cases that I've found or that I could get, because I have started appearing way back when I was as an associate. I became an associate in May 2008. Mm-hmm. Some of the matters, of course, it's just an order being issued, extempore judgments and all of that. But if I have mentioned 12 or less, those will be the judgments that I have appeared myself to argue the matter on behalf of clients.
How many acting stints have you had in the labor court?
I have, I always say it's 3, in fact.
And the duration?
The duration is 5 weeks in January, February 2022, and 1 week in June, July. So that's 6 weeks, and 5 weeks that I've done this year in April, May, and 3 additional days, which was a part-head matter that I insisted that it should be had during recess so that we get, we finalize the matter.
Yes. And have you done opposed motion court in the labor court without counsel?
I have, Chief Justice.
Yes.
Many of my matters, in fact, are opposed motion court proceedings.
Yes. Okay. What can you tell the Commission about challenges relating to concurrent jurisdiction between the labor court and the High Court and exclusive jurisdiction of the labor court?
In what context?
What challenge? Are there any challenges that are posed by the fact that the High Court and the Labor Court have concurrent jurisdiction in certain matters, or are there no challenges?
Chief Justice, I think we had those challenges previously. I think more and more as we deal with matters, as litigants come before courts, that issue seems to be, I think, getting resolved. Of course, we know from the Section 157 that the Labour Court has exclusive jurisdiction on employment matters, and there are, of course, I mean, the court has concurrent jurisdiction with the High Court on contractual disputes, on constitutional issues. So that I think over the past few years, I've not seen many of the challenges or coming before court, or the court having to pronounce on the jurisdiction of the Labour Court or the High Court.
Mm. Now, if you are appointed to the Labour Court, you will have to, among others, deal with applications for interim interdicts. Would you like to share the requirements for an interim interdict with the commissioners?
Indeed, Chief Justice, those requirements are for an interim interdict. You're looking at a prima facie right, irreparable harm, lack of alternative or satisfactory remedy, and balance of convenience.
And what are the requirements for final relief?
For final
interdict?
Yes, for final relief, litigants obviously, or the applicants have to prove the clear right. They have to prove, secondly, lack of satisfactory alternative remedy and irreparable harm.
Are you familiar with the circumstances under which you may, as a judge dealing with a trial, draw an inference in a civil matter, and what the requirements are?
Chief Justice, I think with regard to inferences, the court has to draw inferences from objectively proven facts. So you look at those facts that have been proven, and then you draw that inference and you reach a conclusion whether a certain, whether those factual objective facts looking objectively can lead to a particular decision.
So what are the requirements?
As the proven facts, that's what I have on top of my mind, Chief Justice.
The proven facts?
Yes.
Okay. I'm now going to allow the Judge President to put questions to you.
Thank you, Chief Justice. Good afternoon, Mr. Makhura. Good evening. You have, over the last 2 years, I think, acted 2 terms in the Labour Court. Is that correct?
Good afternoon, Judge President. That is correct.
Yeah. Now, while in Labour Court, you've done trials?
Indeed.
Motion court matters?
Correct.
Urgent role?
Correct. I've done agent role twice.
I'm sorry?
I've done agent role twice.
Twice, okay.
Yes.
And it's quite a lot of work. And you had no difficulties? Did you have any difficulties?
I've not had difficulties. I mean, there was only a small challenge my first acting stint. If you look at my judgments, there's a judgment that relates to a restraint of trade agreement, which I think I've handed down like over about 6 weeks later, which I felt like, because I haven't really at the time practiced much or dealt much with issues of restraint, I felt like I took a little bit longer than I should have.
6 weeks? I have no problem with that time period. Okay. Thank you. And I note you're a qualified engineer, electrical engineer. Shouldn't you be dealing with our load shedding rather than legal issues?
Judge President, I'm not a qualified engineer. I have studied electrical engineering, and it was mainly because I always wanted to go to school. If you look at my CV, there were a couple of breaks in between because of other challenges that made me not to go to school. But whenever I had an opportunity, I'll go to school. So that's what I always wanted to do.
Okay. Now, we've heard you have been in practice for 15 years.
Correct.
Now, in this 15 years of practice, I know now your office is divided into different units, but have you ever acted for an employer in a labor issue, in a labor matter?
I have, Judge President, as I indicated earlier on, Cheryl Thompson and Hazen's practice has, over the past couple of years, really diversified, not only in terms of other areas of practice, but even on the labor matters that we deal with. I have represented employers, indeed, mainly public sector, employers, yes.
I don't know from how the professional bodies prepare their comment, but I assume they speak to their members, and that's how they come to the comments they make. And I noticed that the three professional bodies who have commented on all the applicants or candidates, in this case the BLA, the GCB, and LSSA, they all support your appointment.
I have seen that.
Which I find quite surprising. Anything you can comment on why, what is your involvement in these bodies? Are you involved, besides being a member of the LSSA?
Thank you, Judge President. I have no involvement in those bodies. I don't know how they go about doing the recommendations. So, but I believe that they have supported my candidature after, if we look at the GCB comments, after extensive research of my judgments, my personality probably, and many other issues, because I do believe that as a director also I have, over the past 15 years, I have carried myself with integrity, respect, and I have, my work I think speaks for itself, determination, efficiency. I've always endeavored to live by those values of respect.
Thank you. Tell me, now that you're in such divergent fields, you're even doing criminal work and so on, what can you tell me about derivative misconduct? Because, that's the fashionable phrase nowadays. And it's such nice words, it makes you look like an intellectual. So perhaps you can tell me what it means.
Thank you, Judge President. Derivative misconduct is really about a situation where employees of a company might, or they know about certain misconduct that have been committed, and having known, they don't disclose that, and the employer, based on the difficulty in terms of, trying to establish who committed the misconduct, decides to charge all the employees. We know from the Dunlop judgment of the Constitutional Court now that, in essence, there's no duty to snitch.
I was going to come to that. Thank you. I have nothing further, Chief Justice. Thank you.
Thank you, Judge.
Thank you, Minister. You are covered. Commissioner Ngqeberha.
Good afternoon, Mr. Makhura.
Good afternoon, Commissioner Ngqeberha.
Yes, no, thank you. I also know you just like I know your other colleague. And again, I also regard your skills and talents very highly. Can you just comment on an interesting judgment you gave in the Lutsolonyane matter, which was in the newspapers?
Commissioner Ngqeberha, the last time I checked, there was an intention to appeal that judgment. I'm
but
not
just
sure
tell the
when-
commissioners what it's about. It's some gentleman was fired because they got the minister stuck in a lift.
It was just the facts, if I'm allowed to. I'm not sure if I'm allowed to.
You can talk about the judgment you have given.
Thank you, Chief Justice. I mean, the facts briefly were about the specific employee who held a DDG position, which I have found that in terms of her contract, the SMS handbook applied to her. That was basically incorporated as part of her terms of contract. And in any event, it was clear from the SMS handbook as to who it applies to. So, and the SMS handbook sets out the process that should be followed when disciplining an employee or when there's an allegation of misconduct against an employee. So the employer in that case failed to comply with those provisions, the procedural provisions really. And what happened was that the employee approached the labor court. I mean, the employer terminated the employee without following that procedure, which is incorporated in the contract. So the employee approached the labor court on an urgent basis, seeking an order that there's been a breach of contract, that is the unlawfulness part of the case, and seeking specific performance as well. So I then found that she has, on a balance of probabilities, proved her case, having considered the requirements of the final interdict, which is what she sought before the court, and I found that the dismissal was unlawful. And I proceeded to consider whether specific performance was appropriate, which is the remedy she sought, and I also granted same.
Now, your application is Joburg, Port Elizabeth, or Gqeberha.
Correct.
What's the situation there? Are there two vacancies, or do you have a preference?
Commissioner Ngqeberha, I think the Office of the Chief Justice knows very well where my services will be best needed at the moment. I have showed my interest for both. These are all labor court seats, and I'm happy to go either way.
Thank you, Chief Justice.
Thank you, Commissioner Nyambi.
Just a follow-up on that one, Chief Justice, if I may.
Follow-up, okay.
Yeah. I see, Mr. Makhura, that you are the only applicant for Gqeberha. Are you aware of that?
I have noted that, Commissioner Singh.
Thank you.
Yes.
Thank you.
Thank you, Commissioner Nyambi.
Afternoon, Mr. Makhura.
Afternoon, Commissioner Nyambi.
In the letter of support, it specifies that you insist on making sure that you involve juniors in deliberations and decision-making. If you can share with us the benefit of that arrangement.
Thank you for the question, Commissioner Nyambi. That is a letter from my colleague that I work with. We work as a team. Throughout my career as a director, I've been very passionate about development, growth of young lawyers. I spent I think that's one of the things he said there. I spend a lot of time going to the office, sitting with a number of junior professionals, guiding them. I ensure that almost every matter that I deal with, there is a junior professional, and not just as an administrative staff, but someone who basically runs the file. And I always encourage them that they should not come to me to ask what to do. They must come to me with a practical solution, and we take it from there. So I have, over the years, trained many professionals, and that has been my style, and I've been very deliberate about it. And I ensure that from the first-year candidate attorneys, they start drafting pleadings, and I do not mind spending times, many hours trying to settle the first draft, or after reading it, I ask them to go back and revise that, and that is part of training which I'm very passionate about.
Thank you, Mr. Makhura. Thank you, CJ.
Thank you very much. Commissioners on the virtual platform, I didn't see any indication. I take it.
Questions, 26 clusters.
Thank you very much. We have come to the end. JP?
Sorry, CJ, just one question. I see you answered that you've applied for Eastern Cape, but you've also applied for Johannesburg, isn't that?
Correct.
Is there any preference, anything?
He said he can go to any earlier on. He said it's up to the Office of the Chief Justice.
I am based in Johannesburg, but I believe this body has been entrusted to determine where also those who are appointed, where they will be best suited.
Okay, thank you very much. We've come to the end of this interview, Mr. Makhura. Thank you once again for availing yourself. You are now excused.
Thank you very much, Chief Justice and all the Commissioner. It's been an honor to be here and to be invited.
Thank you.
Thank you.
Thank you.